feel free to make additional information if they have managed to acquire that in the course of yesterday evening and today and this morning. So I'll start with an issue which was raised, at least on a couple of occasions, concerning the visibility of the ICCPR in Malta. I think it was coming from the distinguished colleague from the Netherlands. So I give the word to the Attorney General's office, who would wish to sort of give some additional information in this regard. You have the floor.
Yes, thank you. Basically, in Malta, we adhere to the dualist theory when it comes to conventions and treaties, and that treaties do not automatically form part of the laws of Malta. However, they are incorporated in various pieces of legislation. In this case, the state's obligations vis-à-vis the people are met by having the principles of the treaty, of the convention, inserted into national legislation. And as we have said yesterday, the principles in this covenant are included in a number of pieces of legislation, starting from the Constitution of Malta, which is the supreme law, and various other pieces of legislation, including the Criminal Code and a number of other laws. So they are fully enforceable before the courts of law. However, with regards visibility, I mean, there is nothing visible as such, a piece of legislation which incorporates the treaty as a whole, but the provisions of the treaty are obviously included in the relative legislation. Thank you.
Thank you. Another issue which was raised was the question of the 6 reservations which Malta has. Now, by way of information, we have done our contacts yesterday evening, and we have put across the message that these reservations should be looked into, and looked into with the intent of enabling the system to address them with a view to, at one point, remove as many of them as possible. And the message was put across quite clearly, and the feeling I got was that there is a strong intention to address them as much as possible in the context of what is possible to deliver. And I can, with some optimism, say that in the forthcoming months, there will be serious work to at least address some of them. So at this stage, this is the result of our work yesterday evening on behalf of also the recommendations put forward by our distinguished colleague. Concerning the issue of language as possibly constituting grounds for prohibitive discrimination, and also an issue concerning the National Commission on Equality and addressing discrimination vis-à-vis access to housing and goods and services, I would like to pass on the word to the head of delegation for some additional information.
So it's true that the Constitution of Malta does not yet preclude discrimination on the grounds of language. It doesn't, as well as the main Discrimination Act does not yet address language as a ground. It is true that the Police Act, the European Convention Act, the Mutual Recognition of Higher Qualifications Education in European Region regulations, as well as the Mental Health Act, include the ground of language as a ground of non-discrimination. So within the current cycle of looking at reshaping the human rights mechanism and moving towards a national human rights institution, we will have to look, of course, at the founding law of that institution, and we will look into this comment as to possible inclusion of the ground of language as well in that act. When it comes to the NCPE, the current commission, therefore, for the promotion of equality, I'll just provide some background information as to what it is able to do, what is its scope. So the National Commission for the Promotion of Equality is an independent government-funded body set up by the virtue of Chapter 456 of the Laws of Malta in January 2004. The primary task of NCPE over the years has developed, and it monitors the following laws. Chapter 456, Equality for Men and Women Act, Legal Notice 85 of 2007, Equal Treatment of Persons Order, Legal Notice 181 of 2008, Access to Goods and Services and Their Supply, Equal Treatment Regulations, and Legal Notice 316 of 2011, Procedure for Investigation Regulations. The Commission works to ensure that multi-society is a society free from any form of discrimination based on, and it has two main clusters: sex, gender and family responsibilities, sexual orientation, age, religion or belief, racial or ethnic origin, and gender identity in employment, banks and financial institutions, as well as education. And the second cluster, racial and ethnic origin and gender in the provision of goods and services and their supply. This means that when it comes to housing, entertainment, and transport, the NCP is only mandated to look into racial and ethnic origin discrimination as well as gender discrimination. Now, there was a case investigated by NCPE, in fact, in this regard, in 2012. It was an official investigation on alleged discrimination on the basis of race in access to housing. NCPE received a notification regarding an online advertisement. The advertisement in question contained discriminatory wording amounting to discrimination on the basis of race. The Commission held a meeting with the head of the organization responsible for the website where the advert was published, who explained there is a new system in place which would have precluded the addition of such information. The director further explained that as soon as they became aware of the discriminatory advertisement, it was immediately removed, and the agency subsequently published an apology in a local newspaper and social network. In view of this, the Commission concluded that although the advertisement was discriminatory, the explanation provided of the series of events which gave rise to the publication of the contested advertisement on the company's website, the immediate removal upon discovery of the advertisement followed by the public apology published adequately made up for the effects of the advertisement in question. However, it is clear that if there is further discrimination in such fields, NCPE would be able to intervene and take action, as it is currently mandated. Clearly, any forthcoming human rights institution in Malta would have at least the current mandate of NCPE, but one would hope a much stronger mandate to investigate cases and act upon them.
Thank you. A request for information was also done with respect to how the free childcare system operates in Malta, and on a similar note, the issue of maternity leave. I give the floor to our expert from the Ministry of Education and Employment for some additional information.
Good morning. As regards childcare, it has been in operation now since the 1st of April of this year, so that gives us 6 months of service. The beneficiaries would be children whose parents are in work or in education, and they would be able to benefit for childcare from the age of 3 months up to 3 years, at which age they would be eligible for free kindergarten schooling, compulsory schooling. The definition of parents at work is defined as both parents or guardians who are in work, or a single mother, father, or guardian who is in work and paying social security contributions. It also covers parents who are in education, in which case it is defined as having both parents or guardians who are in education, leading to a recognized diploma or degree, or a single mother or father or guardian who are in education with similar conditions. Parents are entitled to free childcare of all childcare of children of childcare age, and the amount of hours they would get would be pro rata to the mother or single father's employment hours. It is also considered that each family benefits from an additional 60 minutes per day for commuting for the working parents. Families have the option of choosing between the free childcare system or a tax rebate, so it is up to them to choose which service they would prefer. We were also asked about the impact of this service. Given the fact that it is in its initial stages, we have 6 months of service now. However, we know that 1,000 new children attended childcare. The number increased from 1,700 in March to 2,700 in September. It is also something to note that 250 mothers started working for the first time after the scheme was introduced, 65% of which work part-time. In the course of the 6 months, we also had mothers who increased their working hours or returned from parental leave. As regards to maternity leave, in Malta we have 18 weeks of maternity leave. The first 14 weeks would be paid, fully paid by the employer. Then there is the additional 4 weeks maternity leave benefit, which is partially covered by the social security contributions. Thank you.
I thank you. Another issue which was raised was how and which measures Malta takes in order to curb child abuse, and also a request was made whether statistics exist on rape, sexual harassment, and also whether we could provide an explanation for the statistics showing of 0 investigations in this regard. So I give the floor to our expert from the Ministry for Family and Social Solidarity for some additional information. Thank you.
Good morning. Well, with regard to child abuse and the measures we take to curb this abuse, not only physical abuse but also sexual abuse. First of all, I would like to start from the legal point of view. As we said before here, corporal punishment is abolished. So that is one measure. Recently, we also enacted the Protection of Minors Registration Act, whereby any person who is detected of being involved in sexual abuse, be it defilement of minors, pornography, prostitution, his name is registered in a particular register, and employers who are going to employ persons that are working with children primarily, they have to consult this register so that if the person to be employed is in this register, he or she wouldn't be employed. Other measures we have with regard to curb abuse, we have a lot of services. One of them is the Child Protection Services. They deal specifically with child abuse cases, whereby they investigate the families concerned or the settings concerned, and where it is possible or where it is needed, a care order is issued in respect of the children concerned. We have other measures. For example, have a free phone where children and other persons can phone 24 hours. The service is for 24 hours, and they can report, and action is taken immediately. We also have community services where people in the community are reached so that if cases are detected, they will be treated as soon as possible. We have also the Commissioner of Children, whereby they take certain measures to curb abuses as well. And also in schools, we have this program. It's sort of facilitated by an agency, a social welfare agency. It is called BABES. It sort of deals with the preventive side. Kids from an early age are sort of exposed to this feature of abuse, and they have specialized program for these children, so that they will be aware of potential abusers. We also have in place in schools, especially a system, the sexual abuse and other abuse in schools, so that they are be detected in the early years of childhood. With regard to statistics, whereby Mrs. Vaterval talked about sexual harassment, especially, and rape, the 0 indications we have on our statistics. It is confirmed that usually when persons are self-referred, especially, they don't say that the abuse is rape or sexual harassment, especially if it happened in the family. So eventually, when intervention starts, they say that it's probably harassment or rape. So it is indicated in the statistics whereby it is stated, for example, emotional, financial, and sexual. Then the sexual comes there. So rape and sexual harassment, probably later on, it will be indicated under those headings. Thank you.
Thank you very much. And finally, from the list of outstanding issues which we wanted to return to, we also noted that there was a demand for some additional information concerning the increase of women in public life. So I give the floor to the head of delegation to give some additional information in that regard. Thank you.
So currently there are 8 members of parliament who are female out of a total of 69, of whom 1 is a minister and another 1 is a parliamentary secretary. It's true that women are underrepresented in our national parliament. There's no argument around that. However, the number of women elected in the local councils is on the increase, and that's on the upside. In fact, currently 19.8% of the local councillors are female. Although there are no formal mechanisms in place to ensure that women are appointed to positions in national governments, very often elections at national council level serve as a springboard to higher echelons in political life. Hence, increase in female representation at local council level is likely to bring about an increase in the number of female members in the long run in our national parliament.
Thank you very much. With your permission, Chairman, I will now return to the point where we departed yesterday, and we were in the process of answering questions on Cluster 2, in particular questions put forward by Ms. Zabet 4, and we were about to start answering issues related to disciplinary measures in force in detention centres. So I give the floor to our expert from the Ministry of Home Affairs and Security, and then we pass on to the questions that were related to us by Ms. Magadeni. Thank you.
Okay, this question related to what actions were taken in cases of detainees who assault or otherwise attack detention officers. Obviously, if a detainee commits a criminal offence in detention, then he is treated as for any other person who commits a criminal offence. He is taken to court and judged accordingly.
Thank you very much. Now we pass on to the questions, as I informed earlier, put forward by Ms. Magadeni. They are all related, one way or the other, with the issue of irregular migration in Malta, conditions within the detention centres, and also some of the cases that have taken place in the course of the past years in the context also of this particular phenomenon. I have taken note of the following, and my colleague, the expert from the Ministry of Home Affairs and Security, will provide answers to each one of them. Should there be any which I have omitted from my notes that you may wish to return to, please do so after this list of questions are answered. So the first one concerned the issue of Libyan migrants rescued at sea, and the question why these are not subject to Maltese jurisdiction.
Yes, the question related to a specific case which involved a rescue operation by both Maltese and Libyan assets. In fact, a number of the migrants were rescued in the Maltese search and rescue area by a Libyan vessel, and they were taken directly from their own vessel to the Libyan vessel. So it is definitely not a question of jurisdiction, in that they were not even on the Maltese search and rescue vessel. But then again, we have to remember that a search and rescue area is not part of Maltese territory, of course. Within the search and rescue area, the Maltese authorities are obliged to coordinate the rescue, either through the rescue is conducted either through their own means, or else through the utilization of other of the search and rescue vessels of other countries, or else even through other vessels that may be in proximity to an incident, as you all know. So we do not consider that this was a case of non-refoulement or even a question of return, because the people in question were in fact never in Maltese territory and they were never under Maltese custody.
Thank you. In fact, you've touched also on the issue of non-refoulement, and one of the questions was, what is Malta's position vis-à-vis the principle of non-refoulement?
Yeah, in fact, there is a lot more to be said on the principle of non-refoulement. The principle of non-refoulement is incorporated in Maltese legislation, in fact, in the Refugees Act, which prescribes that an asylum applicant may not be returned to his or her country of origin at any stage of the asylum procedure, which means not even when he or she is awaiting an appeal after the case has been rejected at first instance. Statistics published by the UNHCR over the years confirm that Malta's asylum system is indeed readily and easily accessible to those who wish to make use of it. In fact, for years, Malta, in per capita terms, has received the highest number of asylum applications among the 44 industrialized countries covered by the UNHCR's report, and this is a fact. For 2013, Malta ranks the second highest in terms of asylum applications received per capita. Moreover, Malta has had a consistently high asylum recognition rate. In fact, it has consistently exceeded 50% over the years, and very often it has been well above the 50% we mentioned, sometimes even up to 80%. This, of course, depends on the composition of the asylum seekers who apply at any particular point in time, but generally speaking, over the years, Malta has received a large number of asylum applications from persons coming from unstable regions in the Horn of Africa, especially Somalia. So that is some background concerning non-refoulement.
Thank you. Another issue concerned the role of Maltese authorities vis-à-vis the case of the 4 Eritreans and Somalis which were returned to Libya, which touched on the issue of safeguards in case of expulsions. Can you elaborate on that? Thank you.
In fact, it doesn't result to me that we had returns to Eritrea in the years that were mentioned in the question. In fact, many people from Eritrea have reached Malta over the years, and many have been granted either refugee status or subsidiary protection.
Thank you. A question also was put with respect to mandatory administrative detention of migrants and asylum seekers, which also included reference to the maximum length of duration of detention. Can you elaborate on that?
Yes. At present, the Maltese system prescribes a maximum 12-month period of detention for asylum seekers. In practice, what this means, because this question was asked yesterday, if someone is rejected on the 6th month, then he would cease to be an asylum seeker and he could be detained, at least in theory, for a maximum amounting to a total of 18 months. So that answers the question that was asked yesterday. Now, even though we have a theoretical 18-month detention period for those who are not asylum seekers, a review is being conducted, in fact, practically once every month, in order to ascertain whether there is still a need to detain each individual who is in the detention centers. This is already a requirement at law when it comes to those persons who are not asylum seekers, who are irregular migrants and who are detained with a view to their deportation. So a review is carried out often. In fact, yesterday I even mentioned some statistics, and I indicated that out of 353 persons who were released from detention this year, 192 have been released after less than 15 days of detention. So it is not the case that everyone is being detained for 12 or 18 months. And then again, even the number of days of detention for other persons are not particularly high, not as high as is suggested by the theoretical maximum anyway. For instance, 16 have been detained for between 16 and 30 days, 34 for between 31 and 45 days, and 33 from between 46 and 60 days. So in fact, the system in that sense is changing. There are going to be more changes with the implementation in Maltese legislation of the Recast Reception Conditions Directive. The directive will enter into force in July next year, and it will be introducing changes to the legal notice transposing the old Reception Conditions Directive, the one that still applies to this very day. Essentially, we will be introducing the reasons why an asylum seeker may be detained. So each asylum seeker would have to be informed as to the reason why he or she is being detained. Moreover, they would also be informed that they can challenge their detention. Actually, we already informed them today that they can challenge their detention. But there will also be an amendment to the Immigration Act, which will enable each asylum seeker and anyone else who is detained to challenge their detention at any stage of the proceedings. This is something that I mentioned yesterday, but I thought I should repeat it in order to make things clearer. Another question that was asked yesterday was in relation to the period of detention being stipulated by policy and not by legislation. When we will be transposing the new Reception Conditions Directive, it is very likely that we will have a maximum detention period for asylum seekers in the law and not just in the policy. Moreover, there will be also in the law the requirement to review detention on an ongoing basis well before the 12 months elapse. So even though one will have the opportunity to challenge detention, there will also be an ex officio review on an ongoing basis. In practice, we are already conducting that, but it will be also in the law for asylum seekers. I think that touches upon the main points.
Thank you, but there are other points, so I beg you to stay in tune in order to address them also, because a point was made concerning whether the 18-month maximum period runs contrary to the principle of proportionality. Of course, you've touched on the issue in your previous answers, but if you've got anything to add to that, that would be helpful.
Yes. Of course, when it comes to the duration and length of detention, it is a bit of a controversial issue, and the issue of proportionality arises often. In EU law, in the Returns Directive, in fact, there is a theoretical maximum period of detention of 18 months. However, it doesn't mean that each person detained with a view to deportation would actually be detained for up to 18 months, because a regular review of the need or otherwise to detain has to be conducted. So in practice, I think it is quite unlikely that many people would be detained for the theoretical maximum of 18 months. But to answer the question, the total of 18 months detention period is included in the Return Directive.
Thank you. A point was raised concerning whether Malta may be considering the non-custodian measure as an alternative to detention.
Yes. Yes. In fact, I mentioned earlier on that we are going to be transposing the Recast Reception Conditions Directive, which also obliges member states to introduce into national legislation non-custodial alternatives to detention. And our law will also be making reference to non-custodial alternatives to detention, including, for instance, regular reporting.
Thank you very much. A point also was raised of what happens to an asylum seeker's application if this is rejected.
Yes. Obviously, once an asylum application is rejected at second instance, measures are taken to return the person in question to his or her country of origin. There is the possibility, should the asylum seeker have new evidence to submit to the asylum authorities, to submit a subsequent application, something which is provided for in EU law. However, a subsequent application can be submitted only if the person is in possession of new evidence affecting his asylum claim that could not have been available to him at an earlier stage.
Thank you, and I beg for your indulgence for the last 2 points concerning the questions by Ms. Magadeni. A mention was made concerning the judicial review in the context of administrative detention and also the issue of legal aid and how this is provided to the various sectors of the issue. Thank you.
Yes. Starting with the review of detention orders, basically the responsibility for appeals lies with the Immigration Appeals Board. Although it has the name of board, in fact, there are the same guarantees for the Immigration Appeals Board that apply to the judiciary. So basically, the board has security of tenure, and members of the board can be dismissed only in cases of gross negligence, incompetence, or other matters that affect their credibility, so to speak. The members of the Immigration Appeals Board, in fact, are appointed by the President of Malta in consultation with the minister concerned. Given that the guarantees that apply in respect of the board are practically the same as those applying with regard to the judiciary, we consider that it constitutes a valid judicial remedy within the terms of Maltese law. The other question?
The issue of legal aid and how this is applied.
Yes. The issue of legal aid. If I remember well, it was specifically concerned with free legal aid rather than legal aid generally. In terms of asylum legislation in Malta, we are implementing the qualifications and procedures directives of the European Union, which require each member state to have a system of free legal aid at appeals stage. The directives do not require a system of free legal aid at first instance, as you know. Malta has decided to apply the directives in this way. However, it bears noting that even though we do not have free legal aid at first instance, we have one of the highest asylum recognition rates in the European Union, and for years it has actually been the highest. Moreover, most cases at first instance are being heard within 6 months or less. So I think that the statistics themselves point to the adequacy of the system.
Thank you very much. I think that brings us to a wrap-up for the questions or points raised by Ms. Magadeni. And, Chairman, with your permission, I will now skip to the issues which were raised by our dear colleague, Mr. Bouzid, in his questions yesterday concerning 13, 15, and 16. And the first one on my list has to move fast. The first one on my list concerns the issue of measures to banish corporal punishment, which in our explanation might have led to some ambiguity. So I give the floor to our expert from the Attorney General's office.
Yes, thank you. And basically, the point was raised yesterday with regards to a certain ambiguity with regards to corporal punishment. Indeed, if there was some form of ambiguity, this was completely eliminated last February 2014, whereby an amendment to Article 3391G of the Criminal Code makes it a criminal offence for anyone authorized to correct another person to use corporal punishment of any kind. This provision applies universally in Malta, and hence would include parents, guardians, teachers, care workers, prison officers, prison wardens, etc. Hence, we do not see that there is ambiguity, because it's a state of fact that corporal punishment of any kind by anyone is a criminal offence in Malta. Thank you.
Thank you. And for the process of moving on with time, I ask our expert from the Ministry of Home Affairs to touch on the issues of age assessment on arriving irregular migrants, child detention, and also the conditions in Safi barracks and improvements in Mount Carmel Hospital.
Okay, I will start with the age assessment. First off, we have two systems for age assessment. We use mainly the psychosocial model for age assessment of claimed minors who are undocumented. Then we also have the medical bone test, which is, however, used only in cases where there remains doubt as to the age of the minor. So our preference is to go for the psychosocial assessment, which is carried out by experts of the Agency for the Welfare of Asylum Seekers. So that is the procedure we use. They have a model and they use that model. As regards child detention, some years back there was a period when minors would be kept in detention until the first few clearances were obtained. This is now no longer the case because minors are no longer being detained at any stage of the procedure. So this is something that has changed.
Safi barracks and Mount Carmel.
Okay. Now, regarding conditions at detention centers, basically there have been a number of factors that affected conditions at detention centers. First of all, as at the end of September this year, the number of detainees in both detention centers has been of 266. So basically we have had far less people in detention than is the maximum capacity of the detention centers, something which obviously helps towards improving conditions by itself, because when people are more crowded, obviously material conditions are undoubtedly affected. Of course, I have also mentioned the fact that, generally speaking, people are staying in detention centers for a less prolonged period of time. So that is also a factor to be taken into consideration. However, there have been a number of refurbishments at the detention centers. A number of projects have been conducted in order to improve services. So basically, in some cases, new flooring, new beds, and several other, and even ventilation has been introduced in the different detention centers. Basically, Malta has implemented a number of EU co-financed projects over the years that have contributed to an improvement of reception conditions. Be it in detention and even in open centers, in fact, where, for instance, the use of tents has now been completely eliminated, and there are mobile homes where there used to be tents. Improvements have been significant both in detention, in fact, as well as in the open centers. Efforts, of course, are also ongoing within Mount Carmel Hospital with a view to continue improving material conditions generally. Of course, more always remains to be done when it comes to these centers, be they closed, be they open, or be they other centers. And of course, our efforts as regards refurbishments are ongoing.
Thank you. I think the points raised by Mr. Zazescu concerning unaccompanied children, improvements registered in this regard, and also the age determination mechanism have been touched upon by our expert in earlier answers, and also with respect to questions by Mr. Shani, jurisdictions of persons rescued at sea, we have also touched upon that in our answers. And that brings me to the end of the points raised. Thank you, Chair.
Thank you very much, Ambassador Greg. Thank you. Any follow-up questions from colleagues? Ms. Zybert-Four, you have the floor.
Thank you, Mr. Chair. I would like to thank the distinguished delegation for the efforts to answer our questions. I'm still missing information on specific disciplinary action which has been taken in response to the ill treatment which occurred on the 16th of August 2011 in the Zafi Barracks Detention Center. And I would like to clarify that my question did not relate to to any kind of sanctions against the detainees. I ask about disciplinary measures which are in place in order to ensure the safety of the detainees. Perhaps I was not clear about that, and I would like to make this clear. There are also concerns that the inquiries have not been published, and therefore I would like to inquire whether the results have been made public. With respect to abortion, I would like to stress that the committee is very much concerned about the right to life. It is exactly for that reason that the committee regularly expresses concerns, not only with respect to the current state party, but to all states parties, which generally criminalize abortion, particularly if the life of the mother is at stake and if clandestine abortions lead to maternal mortality. The distinguished delegation pointed out that in practice, intervention is not precluded to save the life of pregnant women. But it also made some exceptions which were not totally clear to me, so perhaps that requires some clarification. I would also like to know how the state ensures that medical doctors take active action to ensure the survival of the mothers, given the fact that there is still a general prohibition on the textbooks with regard to abortion, and that they are constantly running the risk of being prosecuted under Article 243 of the Criminal Code. Thank you.
Thank you, Ms. Zybert-Four. Ms. Majadina, you have the floor, ma'am.
Thank you very much, Chairperson. I'd also like to thank the delegation for the responses to the issues I raised yesterday. I'm quite happy with responses to issue 14, and I also thank the delegation for follow-up responses to the issues on women. But on issue 12, I'm grateful for the responses were given this morning. As I stated, though, yesterday, there are different interpretations of what happened in 2010 in the case of the Somalis and Eritreans who were deported or sent back to Libya. With regard to this incident in 2012, the second incident, we are told that Malta appears to have been first on the scene when Somalis were found and were subsequently sent back to Libya. Because Malta was first on the scene, it appears that these migrants fell within Malta's effective control, and that Malta admitted in its fourth report of the European Committee Against Racism and Intolerance that these events, the search and rescue in Maltese waters, occurred within Malta's own search and rescue region, where Malta held jurisdiction. I just wonder whether you would like to tell me more about this, as well as what happened. Well, we are told that in 2013, Malta did not proceed with a plan to transfer a group of persons who were intercepted by the air forces, the Air Force of Malta to Libya. So obviously this collective expulsion did not take place, but I am interested in the first issue of the Somalis in Maltese waters. Thank you.
Thank you, Ms. Majadina. Mr. Bouzid, you have the floor, sir.
شكرا سيد الرئيس. أشكر الوفد على
Thank you very much, Chairman. I wanted to thank the delegation for all of the answers to the questions that I asked. But regarding question 13 and the answer that we've been given here, it appears that the amendment to Article 339 relates to the prohibition of all forms of corporal punishment. And 154 also talks about this form of punishment. I wonder whether you could give us more information about this Article 154. This is still a matter for the consideration and evaluation of the courts. And I wonder whether you have really eliminated all possibility of corporal punishment. Are you also going to repeal 154 to make sure that it does not give rise to any interpretation that can lead to corporal punishment? Thank you.
Thank you, Mr. Bouzid. We're already now running behind time again. I'm giving the delegation the choice either to respond now to the questions that have just been raised or to wait and to get the questions from colleagues on the next cluster and then wrap them together, whichever you prefer.
I think your suggestion, Chair, is the right one. We'll get further questions and then we'll calculate time available at the end of it.
Okay, thank you very much, Mr. Grech. So the questions that colleagues have raised will be responded to, but in the context also of responses to the responses of the State Party to our next round of questions in Cluster 3, which is slavery and servitude, the right to fair trial, independence of the judiciary, and juvenile justice. And there, the first speaker on my list is Ms. Waterfall. Ms. Waterfall, you have the floor.
Thank you, Mr. Chair. I thank the delegation for their responses to my questions. I'm going to ask questions on issue number 17. Malta has two anti-trafficking national action plans. I would like to know, in this context, what the impact is of this anti-trafficking national action plan. How effective is the implementation of this plan? In paragraph 119 of your replies, you stated that the victim referral mechanism was further developed by means of standard operating procedures. Are these procedures in operation now, and how do they work in practice? Maybe you can elaborate more on these procedures. In paragraph 120 of your replies, you also stated that it is considered that the concerted efforts by this unit, and then you mean the police fire squad, assisted in improved identification of human trafficking cases, as an increase in trafficking cases being investigated was witnessed, followed by an increase in the arraignments of suspected perpetrators in court. My question is, have you got data to support this? In paragraph 121, you have also stated that in 2013, 7 adult females were formally identified as victims of human trafficking, exploited to provide sexual services. Can you provide us with numbers of 2012, 11, and 2010? Because you only give us numbers of 2013. And my last question is, do you have a program or policy in place to protect and support victims who cannot return to their countries of origin? And I mean victims of trafficking in persons. And with that, Mr. Chair, I thank you, and I thank the delegation in advance for their responses. Thank you.
Thank you, Ms. Rattenfeld. The next speaker on my list is Ms. Zybert-Four. You have the floor, ma'am.
Thank you, Mr. Chair. Following up on my colleague, Ms. Waterfall, I would like to turn now to issues number 18 to 20. With respect to the judicial reform, that is issue number 18, I would like to inquire about the outcome of the review process. Which proposals have been put forward by the Justice Reform Commission in November 2013? Which changes are underway in the reform, which according to the state parties' replies started in March 2014? More generally, I would like to know what deficiencies have been identified by the Commission of the Maltese justice system. I would like to recall that there have been concerns about delays and overlength of judicial proceedings for quite some time. Turning now to issue number 19, the age of criminal responsibility, I have noted with great satisfaction that Article 35, paragraph 1 of the Criminal Code was amended in 2014, raising the age of criminal responsibility to 14 years. But I'm afraid that concerns about the exclusion of minors between 16 and 18 from juvenile court proceedings remain. Are these juveniles tried as adults? At least this is what seems to be the case, reading Article 6, paragraph 1 of the Juvenile Court Act, which provides for the referral of cases to the competent court of magistrates as soon as an accused turns 16. Is it right that minors who stand as co-accused with adults or other minors over the age of 16 in relation to the same crime are not heard by the juvenile court? Finally, Mr. Chairman, with respect to issue number 20 and the right to access to a lawyer for persons deprived of liberty, there are concerns that the lawyers are not present during police questioning. Is it right that defendants are only allowed to consult a lawyer before an interrogation and that the lawyer cannot be present when the interrogation takes place? The replies of the state party only refer to a provision of the criminal code that is Article 534 AB, paragraph 1, but neither is the content of the provision given, nor do the replies explain to what extent the provision addresses the issue. So I would like to have some clarification on that. Furthermore, I've learned from the state report that there may be delays in access to a lawyer up to 36 hours under specific circumstances. I would like to recall that this committee's general comment on Article 14 stipulates that, and I quote, "The right to communicate with counsel requires that the accused is granted prompt access to counsel," quote end. I should also note that the right to prompt access to a lawyer is essential also to prevent ill treatment. So we are not only talking about Article 14 over here, but also Article 7. I should also note that the right to prompt access to a lawyer is essential also to prevent ill treatment. Therefore, any restriction appears to undermine the effectiveness of this right as a safeguard against ill treatment. Has the state considered alternative safeguards to ensure the proper administration of justice? Finally, I would like to inquire whether it is true that detainees lose their right to remain silent once they request a lawyer, and how this can be reconciled with the guarantees under Article 14 of the International Covenant. I thank the distinguished delegation in advance for its replies and thank the chair for giving me the word. Thank you.
Thank you, Ms. Zybert, for. I think that's the end of the list on this cluster. So I can return the floor immediately back to the delegation, acknowledging that it may need a few minutes just for consultation, but I'm not suspending the meeting.
Thank you, Chair. We would require 2 minutes for consultation. Thank you.
Colleagues, we're back in action. The delegation has concerted commendably rapidly, and I return the floor to the delegation. Ambassador Grech, you have the floor when you're ready.
Thank you, Chair. We shall start with the supplementary questions that were made after we finished our first intervention, and then we will proceed, with your permission, to answer questions on Cluster 3. Thank you, Chair. So, concerning questions from Ms. Zybert relating to specific disciplinary measures in place vis-à-vis the August 2011 case, I pass the word to our expert from the Ministry for Home Affairs. Also, there was also the issue raised in order to speed up our reactions, the issue of inquiries, why they have not been published. I think we can start at that. Thank you.
Okay. As a matter of fact, the latest inquiry, or rather the inquiry in relation to the latest incident, that of 2014, has actually been published. The other inquiries, insofar as I am aware, have in fact not been published, although the results of the inquiry, or rather the recommendations made by the first inquiry, were in fact published and were communicated to you in our replies, whereas with regards to the second incident, as I explained yesterday, disciplinary measures were taken vis-à-vis officers responsible, and 3 officers are actually being taken to court in connection with criminal proceedings over their involvement in the incidents. So that is the first point. As regards the second point, of course there are rules for detention officers to follow with regards to their treatment of detainees, and they have also been provided with training in this regard. Naturally, where there are infringement, disciplinary measures may be taken, and these vary depending on the gravity of the particular circumstances, with the maximum penalty in terms of disciplinary procedures being dismissal. However, whenever a detention officer commits something that is tantamount to an offence in terms of legislation, then action is taken criminally and not just with regard to discipline. So that is the first point. With regards to search and rescue, there is not much more than I can add, in the sense that Malta's search and rescue obligations are quite clear. When it comes to its own search and rescue area, it is responsible for the coordination of rescue and to ensure that the person rescues are taken to the nearest safe port within the meaning of the relevant SAR conventions. In terms of Malta's legal obligations under SAR, it is meant to ensure that those rescued are taken to the nearest safe port. There is not much else I can add to this with regards to interpretation over search and rescue issues. As regards the specific case of 2010, over which there have been conflicting versions doing the rounds, I have recorded for you the official version that is available through the Armed Forces of Malta, and we consider that to be the right version. As regards questions concerning human trafficking, first of all, we have registered an increase in the numbers of persons identified and even persons arraigned following the commencement of actions pursuant to the 2 action plans. I will be providing detailed statistics in due course within the 48-hour time frame, because I do not have statistics for all the years here with me. The standard operating procedures are operational, and they are also available. In fact, should you wish, I have a copy with me for you to be able to look into them. And as to their implementation, The implementation is monitored by the Monitoring Committee, which is a high-level committee meant to ensure that the authorities in question perform their tasks appropriately when it comes to human trafficking. And on a more on-the-ground level, we also have a task force that is meant to ensure liaison between the different authorities involved in the fight against human trafficking. As you know, one of the most difficult things when it comes to human trafficking is to ensure that everything is working well, because there are many different authorities involved, and it is not just the issue of apprehending offenders, but also the issue of protecting the victims. As regards victim protection, I am going to pass the floor to my colleague from the ministry concerned in order for her to give you information on the support that is given to victims who are identified.
So with regard to help to victims of trafficking, within Agency Appoġġ, we have a focal person who is specifically in charge of providing help to these victims. This help ranges from social and psychological help, financial help if they are without any money, legal advice if they need legal advice. We offer shelter as well if they don't have any place where to go. We help also with interpretation services if they need some interpretations to documents, etc. With regard to repatriation, we help them also if they want to go back to their place of origin. This we do with the help of the Organization of Immigration, International Organization of Migration. Thank you.
Thank you very much. The point was also raised by Ms. Van der Vaal concerning whether it is considered by the police vice squad assisted in the arraignment in court. Can you add something to that? Do we have any data to support this? Can we provide this?
Yes, we will be providing data concerning arraignments. Arraignments are in fact conducted by the vice squad, which is the specialized unit. Because in terms of human trafficking, most human trafficking cases, the prosecution is in fact the police. That is part of the Maltese system. So that is in relation to one of the questions. Then there was another question concerning, yes, the data, which will be provided in due course, and then the other issue on whether we have a program relating to victims of trafficking who cannot be returned. So far, the victims of trafficking we have encountered were mainly from China, from different countries in Eastern Europe, including Ukraine, Russia. Those would be the main nationalities. We even once had a new national, in fact. So far, we did not really encounter the problem of victims of human trafficking who cannot be returned. Our system provides for the issuance of a residence permit to victims of trafficking, something which transposes the European Union legislation on human trafficking. However, there are no apposite provisions on victims who cannot be returned. One would imagine that if such a case were to arise and, for instance, the victim cannot be returned due to the fear of persecution, for instance, in the country of origin, then I would imagine that the asylum provisions would come into play. Of course, as you know, asylum does not apply only in respect of persecution from state actors, but also in respect of persecution by non-state actors if these have the power that one would normally associate with a state. However, we do not have specific provisions on victims who cannot be returned. So far, we have not encountered that problem either, to be honest.
Thank you very much. In response to questions by Ms. Seibert for judicial reform, right to access to a lawyer for persons, the 36-hour delay which was mentioned, and also administrative safeguards. I'll give the word to our representative from the AG's office. Thank you.
Yes, thank you. With regards how minors are tried in our courts. Basically, with the new amendments, minors under 14 years of age are totally exempt of criminal responsibility. Minors between the ages of 14 and 16 are tried before the criminal court, while 16 and over are tried before the normal courts. With regards to access to a lawyer, there is a current EU directive which I believe was incorporated into Maltese law, but I can double check and get a reply within the 48 hours just to give the precise indication where it has been transposed. However, the right to a lawyer extends not only to consulting a lawyer before interrogation, but the directive applies also to access to a lawyer during interrogation, and it specifically states that the lawyer can actively participate in the interrogation process. So I just wanted to point that out. With regards and we even included the rule of disclosure as part of the directive, which wasn't there before. However, now we have the rule of disclosure whereby the interrogating officers are obliged by law to disclose all information which they have against a person while interrogating them. With regards the fact whether one loses the right to remain silent when he is assisted, well, he doesn't lose the right to remain silent. However, there is what we call the rule of inference. So if an accused is assisted by a lawyer but decides not to reply to any questions put forward to him, this thing is not taken into consideration as if it is an admission, but the adjudicating authority, whether it be a jury or a judge or a magistrate, can obviously draw inferences on the fact that the person did not reply to any question. Thank you.
Thank you very much. I think, Chair, that brings us to the end of our answers for this cluster.
Excellent. Thank you very much, Ambassador Grech and your colleagues. Now, follow-up questions from colleagues in response to the answers that we've just heard. Mr. Flinterman, you have the floor.
Thank you, Mr. Chairman. I have a question about the last the reply given by the representative of the Attorney General's Department to one of the questions raised by Madame Seibert-4, and that is the issue of inferences that can be drawn from the silence of a suspect under the 2002 amendments to the criminal code. I once again read the relevant paragraph in the report, paragraph 133, and I'm yet not fully convinced that those amendments to the criminal code, which have as a consequence that a suspect refusing to be interrogated, or rather who chooses to remain silent, is running the risk of having an inference drawn against him if later she or he takes the witness stand, is fully compatible with the obligations under Article 14, paragraph 2, which relates to the presumption of innocence. And I would like to invite the representative of the Attorney General's Department, through you, Mr. Chairman, to give some further clarifications in this respect, and maybe also to refer to the practice in Malta under the amendments to the 2002 criminal code. That's my first question, Mr. Chair. And my second question is a point where I need some further clarification, and that is our concern that we raised in the list of issues about the independence and impartiality of the Refugee Appeals Board. Earlier on, we received some information on the migration appeal boards. That's not the same, as I've understood from the discussion so far. In paragraph 127 of the replies to the list of issues, we are informed that the members of the Refugee Appeals Board enjoy security of tenure. They are appointed for a period of 3 years. But during that appointment, they can only be removed from office by the Prime Minister on the grounds of gross negligence, incompetence, or acts, omissions, or conduct unbecoming a member of the board. And for that reason, it's considered that the members of the board, of the Appeals Board, enjoy security of tenure, and that the independence of the Appeals Board is fully safeguarded. I simply would like to have some information in this respect. Would it be possible for the delegation to inform us about the composition of the board, whether or not such reappointments have taken place after the period of 3 years? Simply to have some more information in order to indeed come to the conclusion that the independence of the Refugee Appeals Board is indeed fully safeguarded. Those are my 2 questions for the follow-up, Mr. Chair. Thank you.
Thank you, Mr. Flinterman. If there are no other follow-up questions, I just have one myself relating to the issue of possible return of trafficking victims, and the response, as I understood it, was that there wasn't the problem of trafficking victims facing the prospect of return to a country to which they cannot be returned. I think that may not be the only issue here. The issue is how to get the cooperation of victims of trafficking. And if they're threatened with return to where they came from, regardless as to whether their fate in the place they return from, they may be unwilling to cooperate and continue to be the victims of then unidentified and unprosecuted perpetrators, organizers of trafficking. So the underlying question is there a system of ensuring that possible victims of trafficking will in fact be able to not be under the threat of return to somewhere they don't want to go back to in the context of their cooperating with an investigation into trafficking? No other questions, so back to the delegation. Ambassador Gregg.
Thank you, Chair. Addressing the questions put forward by Mr. Flinterman, the issue of inferences, our colleague from the AG's office has informed us that he will submit to provide further information within 48 hours on this. And concerning the independence and impartiality of the Refugee Appeals Board and the Migration Appeals Board, I give the word to our expert from the Ministry of Home Affairs.
Yes, first of all, I confirm that the Immigration Appeals Board and the Refugee Appeals Board are not one and the same. In fact, the Immigration Appeals Board has been established in terms of the Immigration Act. It hears appeals from different administrative decisions, including decisions relating to detention, but also decisions relating to legal migration and visa issues. So basically, that is the remit of the Immigration Appeals Board. The remit of the Refugee Appeals Board is far, far more limited because it only hears appeals from decisions by the Office of the Refugee Commissioner. It basically only hears cases of asylum, therefore, and it has been established in terms of the Refugees Act. Essentially, the Refugee Appeals Board can overturn any decision by the Office of the Refugee Commissioner. It can turn a rejection into subsidiary protection into refugee status, and so on and so forth. However, if someone has been granted subsidiary protection, he cannot be rejected at second instance. But should someone have been rejected at second instance, he can get subsidiary protection or refugee status, or if he applied after having obtained subsidiary protection, then he would either retain his status or else be granted refugee status. So that is the basic rule as concerns the Refugee Appeals Board. As regards independence, the models for the Refugee Appeals Board and the Immigration Appeals Board are ultimately very similar in the sense that you will observe that the legal provisions are not identical, but they are very nearly identical. They are very nearly the same, and they both enjoy security of tenure, and we consider that the rules governing their appointment and, above all, the rules governing their dismissal are in many ways equivalent to those which obtain in the case of members of the judiciary, and that is why we consider the boards impartial and independent. Even though there is the name board attached to them, it is not an administrative board. In Malta, we also have administrative boards, but these specific boards are considered to be of a judicial nature. That is all I can add. Yes. On security of tenure, I think that I spoke. Basically, it relates to the fact that dismissal can only take place in view of gross negligence, in view of incompetence of members of the board, and not for other reason.
Thank you, colleagues from the delegation. I think that's it then. We can now move on to the fourth cluster. That's questions 21 to 25. Notably, right to privacy, marriage and family life, freedom of expression, freedom of conscience and religious belief, children's rights, and dissemination of information about the covenant. So, colleagues have the floor. The first speaker on my list is Mr. Flinterman. Mr. Flinterman, you have the floor, sir.
Thank you, Mr. Chairman. Yes, indeed, we are moving to other very important parts of our covenant. And today I will address some issues under the right to privacy, marriage and family life. I think yesterday the head of the delegation in his opening statement quite rightly very much emphasized the important step that has been taken recently by Malta with the adoption of that very important act, the Civil Unions Act of 2014, April 2014, 5 months ago now, almost 6 months ago. And yes, indeed, I think that we all consider that a very big step forward in the protection of human rights for all. Because that particular Civil Unions Act of 2014 equates civil unions between persons of the same sex or of the opposite sex, equates such civil unions with marriages in all its dimensions, both in terms of procedure and in terms of substance. And the partners have, in such civil unions, have equal rights such as spouses in a marriage. And it would be interesting to know what the recent experience under this act has been since April 2014, over the past 6 months. How many people, men, women, have used the provisions of this new Civil Union Act? What the percentage is of those civil unions in which the partners are of the same sex, and how many people would have chosen the civil union although being of the opposite sex instead of marriage. But when I was reading this good news and when I was listening carefully to the head of delegation yesterday, the question came up with me why the state party had not made yet a somewhat bigger step in the sense that the state party opened marriage not only to what we are used to, partners of the opposite sex, but also those who wish to be married and are of the same sex. And I would like to invite the delegation to share with us the discussions that have been going on in Malta on the preparation and the final adoption of the Civil Unions Act. Because one inference that you could draw from the Civil Unions Act is that same-sex couples who are united in a civil union are still inferior to those who are united in a marriage. And there is a highly reputed non-governmental organization that has addressed this issue and has labeled this particular act, and maybe those words are rather strong, but let me just quote them, as a perpetuation of the, in quotes, separate but equal doctrine. Same-sex partners are treated equally, but yet they are separate. And my invitation to the delegation would be to share with us their comments on, its comments on this issue. That's my first point. The second is, the second part of issue number 21 relates to the refusal of the marriage register in Malta to allow migrants who have not qualified for refugee status to for refugee status or for subsidiary protection to get married. And the marriage register bases, despite different advice of the parliamentary ombudsman, his refusal to do so on the basis that rejected asylum seekers may obtain the necessary documentation. And secondly, that rejected asylum seekers should not have an advantage over all other applicants who have no regular immigration position. And as I said, the marriage registrar is doing that, despite the call of the ombudsman, the parliamentary ombudsman, to change his policies. And the state party is justifying this policy by referring to Article 12 of the European Convention on Human Rights and Fundamental Freedoms in paragraphs 139 and 140. And if you allow me, Mr. Chairman, I would like to read Article 12 of the European Convention on Human Rights and Fundamental Freedoms, which reads that men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. And in paragraph 140, it is said that, thus, the Convention also clearly stipulates that national laws are to be observed. And for that reason, the state party is of the opinion that the policy of the refusal by the marriage registrar is compatible, at least, with Article 12 of the European Convention on Human Rights and Fundamental Freedoms. But I would like to indicate, and I'm coming back to some extent to the discussion that we had yesterday, that there are important differences between the European Convention on Human Rights and Fundamental Freedoms and the Covenant on Civil and Political Rights. I would like to refer the delegation to the Article 23, paragraph 2 of the Covenant, where it is said that the right of men and women of marriageable age to marry and to found a family shall be recognized, without a reference to national laws. I'm not suggesting that national laws are not important, but what is important that in the Covenant, the right is put forward as the principal concern. And my question to the delegation would be whether the delegation would be willing to comment on this, to comment on the differences of the obligations under the Covenant and the European Convention on Human Rights, and to see to it that the primary right of everyone to marry is recognized in the context of Malta. And that brings me to an issue which was not raised in the list of issues, but I think it should be highlighted here because it is an important aspect also, the protection of human rights. And that is that in paragraph 336 of the report, we are informed that after a referendum in 2011, divorce is now possible in Malta. And before 2011, divorce was prohibited. And once again, I think that's an important step taken by the state party Malta. And in paragraph 336, it is indicated, a number of conditions are indicated which have to be fulfilled in order to obtain a divorce. And my first question would be whether those conditions are the same for both spouses and whether the delegation could inform us what exactly is meant by the condition that, and I quote, spouses must have lived apart for at least 4 years before they can get obtain a divorce. In other words, the spouses filing for divorce need not be legally or de facto separated. And I would like to invite the delegation to inform us what other grounds exist for divorce than those mentioned in paragraph 336, and again, whether those conditions and grounds are the same for women and men. And that brings me to issue number 22. That is a small, but nevertheless, I think, highly relevant issue in which we do not have any further information from the state party. It is the issue that of the visually impaired, let's say the blind people in Malta, who are obliged to vote verbally in front of a group of people representing political parties and the electoral commissions. And our question to the delegation, to the state party was whether that practice is compatible with Article 17, protecting the right to privacy, and Article 25. And in the response, we are informed that the matter is under consideration and that discussions will be taking place with a view to finding a solution. And does that mean, that would be my question to the delegation, that the delegation agrees that the practice is incompatible with Article 17 and Article 25? And I would like to emphasize that Article 25 provides that elections should be held by secret ballot. And that's also underlined in the Committee's General Comment number 25, and later also reconfirmed in Article 29 of the Convention on the Rights of Disabled Persons. And my question is simple. What time frame is there to come to a solution of this problem which is compatible with the obligations of the state party under the covenant? Thank you very much, Mr. Chair.
Thank you, Mr. Flinterman. The next speaker on my list is Ms. Majardini. You have the floor, ma'am.
Thank you, Chair. I don't have much to ask except for just a quick question on the average age of marriage. I read that there's no decision to raise the average age of marriage from 16 at the moment. I'm wondering why this is so, especially given that in the replies, in the report, we're told that the average age of young people getting married has increased. But also, the state report informs us that the age at which a young person ceases to be a minor is 18. So I'm just wondering why the age of marriage couldn't be increased to 18. Thank you. Thank you, Mr. Chair.
Thank you, Ms. Majardina. And Mr. Bouzid, you have the floor, sir.
شكرا سيد الرئيس.
Thank you very much, Chairman. Chairman, I wanted to raise questions 23 and 25. First of all, on 23, I'm wondering whether Malta is considering the decriminalization of defamation. We have also asked about attacks vilifying the church. and attacks against the church in general, and how such criminalization is seen to be pursuant to the state's commitment under Article 19 and General Comment 34. Those were the questions addressed to the state party, and in your replies, you say that there was no plan to decriminalize these offences. And reading between the lines, I also deduce that there is no such inclination, but you don't explain why you have this position, which on the face of it is not in compliance with the Covenant, notably Article 19 of the Covenant, as interpreted by the committee in General Comment 34. So defamation very much limits the freedom of expression in all democratic regimes. This is in 19 paragraph 3 of the Covenant, which goes into this question in some detail. So on vilification and the attacks against the church and religion in general, you have stressed the maintenance of the status quo. You have said that you do not intend to change this position. This does not seem to be in line with the commitments pursuant to the Covenant, particularly Article 19 and the committee's General Comment 34. A question: why do you insist on this position? And how is this position justified in your view? Could you envisage having another approach, taking another position vis-à-vis what is said in General Comment 34? I also have a further point to raise in relation to question 25, which relates to the dissemination of the Covenant and the first optional protocol, and the second report that you are submitting here. Question 25 also goes into details such as the participation of NGOs, the Ombudsman's Office, civil society in general, and the National Commission for the Promotion of Equality. Have all of these various bodies taken part in the preparation of your second report, and if so, to what extent? Now, in answer to this question, you say that the Covenant has not been dissimulated. There have been no specific campaigns organized to raise awareness about the Covenant, campaigns organized by the ministries or the government. You also say that the only body that has been involved in the drafting of the report is the NCPE, the National Commission for the Promotion of Equality, in other words. So my question is why there has been no dissemination of the core documents, and why has there been no participation with the general public and civil society in preparing their report? And do you intend to change this practice in future? Civil society, NGOs, the Ombudsman's Office, why were they not fully involved in the preparation of the State Party report? Do you intend to put this right for the next report, to ensure that all parts of civil society can fully play their role when preparing the State Party's next report? Thank you, Chairman.
Thank you, Mr. Bouzid. Mr. Sitil Singh, you have the floor.
Thank you, Chairman. I have one very brief question concerning freedom of expression, and that's issue number 23. I see in the second periodic report at paragraph 309 that the Maltese Press Act does not define libel or defamation. And it says there that the courts have adopted a a principle in medio stat virtus and relying on public opinion to say what is libel or defamation. My question is, does this appreciation evolve with time? How do the courts make an appreciation of public opinion in that respect? And it would be very interesting to get some kind of illustration or case law from the delegation on this appreciation of what is libel or defamation, which is very important insofar as the freedom of the press is concerned. Thank you, Chair.
Thank you, Mr. Situl Singh. And perhaps any other colleagues? No. Perhaps I could just add a gloss to on the same issue on the point referred to by Mr. Bouzid. When the delegation responds on why they think the protection of one religion in relation to, from defamation is compatible with the covenant, to reply not just perhaps in terms of Article 19, but also in terms of Article 18, which protects freedom of religion, conscience, and belief, which includes non-religious belief, and indeed Article 26, which prevents discrimination on any such grounds. No more questions. Over to the delegation, again with a moment to consult by all means.
Yes, thank you, Chair, with your indulgence.
Okay, colleagues, the delegation's already done its quick consultation and is ready to feed back to us. You have the floor, Ambassador Gregg.
Thank you very much, Mr. Chairman. We will react to the questions put forward by Mr. Flinterman, particularly his first intro regarding adoption of Civil Unions Act 2014 and right to married life. And I give the floor on this issue to the head of the delegation. Thank you.
So, I'll reiterate that the Civil Unions Act was approved by Parliament and received parliamentary assent in April 2014, so that's very recent. Through this Act, all aspects related to rights and duties found in the Marriage Act apply mutatis mutandis to civil partners, with the sole exclusion of matters related to civil weddings. Civil unions are open to different sex and same-sex partners indiscriminately. The Act also ensures that foreign unions of same-sex partners are recognized locally. This means that in Malta, foreign same-sex registered partners are registered as civil partners, while different sex and same-sex spouses are recognized as married couples, enjoying equal rights and duties as their Maltese counterparts. Adoptions by civil union partners are regulated in the same way as those by spouses. Now, specifically with regard to the questions that were asked, the NGOs in Malta, all LGBTI NGOs in Malta, have been party to the formulation of this act. In fact, unlike perhaps other acts in other countries regarding civil unions and regulations of such civil unions, our law was entirely prepared by civil society and submitted to government as a proposal put forward by them. Also, I have to add on that one that no civil society organization in Malta that works in this field has challenged the current law. Much to the contrary, when the law was adopted, we've had the biggest party ever in front of Parliament celebrating the adoption of a law. It never happened before that there were more than 4,000 people present in the square in front of Parliament celebrating the adoption of the law. So I'm quite astonished by your comment, actually, that NGOs are challenging the current situation, that it is inferior to marriage. As in fact, while the law refers to the term civil unions, in fact, in colloquial terms, people say that they are getting married rather than entering a civil union. I'm not aware of different sex couples actually interested, that have expressed interest so far in entering a civil union. That does not mean to say, however, that they cannot. Much to the contrary, it was part of the initial proposal, the proposal, in fact, that was taken to Parliament, where it was ensured, in fact, that no separate status was provided to civil union partners, and that, in fact, this idea of separate but equal did not enter Maltese legislation. In fact, to some degree, civil unions are seen as a separate institution that is not marriage, however, providing the same rights and duties as marriage does. One other important aspect to say, to refer to here is the fact that in Maltese law, there is no residency requirement or nationality requirement when it comes to civil unions. This means that a couple from a third country could enter into a civil union in Malta, much in the same way that a couple composed of one resident in Malta and another resident in another country can enter into a civil union in Malta. So that's basically what I had to say in regard to this. Also, importantly, in Maltese law, there is a schedule that details a full list of civil union laws, or registered partnership laws, or equivalent laws from other countries that are recognized as equivalent to Maltese civil unions. Important to say here, the assessment there was not related to the rights provided by the country of origin, so where the civil union was registered, because most often, in fact, the regime is much weaker than the one provided for in Malta, but to the entry and exit procedures of such a union. That is, whether one actually registers in order to accede to it, or whether it was automatic. The automatic ones we did not include, and whether one has to have a formal dissolution of such a union or not in order to exit out of it. Once again, those that did not require a formal exit were not included. So, in actual fact, most probably, the Maltese Civil Union Act is the one that is closest to marriage in the whole world. I stand to be corrected on that one, but I'm fairly certain of it.
Perhaps the head of delegation would like to also say a word or two on the issue of divorce being introduced in Malta recently.
Yes, without entering into the merits of the conditions for exit, for the divorce itself, that is, from an existing marriage, I can assure the distinguished members of the committee here that the same conditions apply for males and females, and that there are no rules, in fact, that would favor one party over the other in a divorce procedure.
Thank you. Also in the list of questions by Mr. Flinterman, one point was raised concerning the refusal of the marriage register for migrants who may not qualify for subsidiarity to get married. The word to our Ministry for Home Affairs.
Okay. First of all, the public registry does recognize rights in relation to marriage, and third country nationals are of course not precluded in any way from having their marriage registered in Malta. There are requirements to provide documentation for the simple reason that a marriage has to be registered between identifiable persons. Now it is recognized that there are certain persons who cannot obtain these documents. It is recognized that a refugee cannot obtain these documents, and it is recognized that a beneficiary of subsidiary protection very often cannot obtain these documents. So, wherever there is a case that there is a justifiable reason for a person not to produce the documents required by the public registry, the marriage is registered anyway. Of course, no one expects a refugee to produce documents from his country of origin, for obvious reasons. Those who do not have their marriage registered are essentially those who do not produce the documents required, which documents are required of everyone anyway, and who have no justifiable reason for not producing the documents. If you are a rejected asylum seeker, and basically have nothing to fear from your country of origin, and there is no impediment precluding you from obtaining this document, then we see no reason why the requirement to produce documents should not be upheld.
Thank you very much. Another point which was raised in this first list of questions concerned the visually impaired who are obliged to vote in front of an electoral commission. I give the floor to our expert from the Parliamentary Secretary for Active Ageing and Disability.
Thank you. It is to be noted that not only blind persons vote verbally in front of a group of people representing political parties and electoral commissions, but also others who seek this type of assistance. The ballot papers are also, the voting sheets, are also available in Braille and MP3 formats, and made available upon request. The assistant electoral commissioners are also bound to secrecy by oath, and are trained to provide this assistance prior to the undertaking of the electoral process. Notwithstanding, discussions with the Electoral Commission between the Secretariat of the Parliamentary Secretary for Persons with Disability and Active Ageing, and the Focal Point Office for Persons with Disability have started. It is to be recalled that Malta has a reservation on Article 29A 1 and 3 of the United Nations Convention for the Rights of Persons with Disability, where, while declaring its full commitment to ensure the effective and full participation of persons with disabilities in political and public life, including the right to vote by secret ballot in elections and referenda, and to stand for elections with regard to Article 29A(1), Malta reserved the right to continue to apply its current electoral reservation insofar as voting procedures, facilities and materials are concerned. And with regard to A3, Malta reserved the right to continue to apply its current electoral reservation insofar as assistance to voting procedure is concerned. The above interpretative statement and reservations were confirmed on the ratification of the United Nations Convention for the Rights of Persons with Disability. Thank you.
I thank you. We skip to the question by Ms. Majadena concerning the average age of marriage. My instructions are that, as we speak, the government intends to maintain this policy. With regards to the questions raised by Mr. Bouzid, particularly regarding the defamation limits and freedom of expression, and also relating to the decriminalization of defamation, again, the instructions I have is that the government does not intend to change the policy as it stands. And also with respect to questions by Mr. Bouzid relating to the dissemination of the ICCPR in the context of the first optional protocol, I give the word to the head of delegation for some additional comments.
So it is indeed true that Malta perhaps could do more in visibilizing human rights in multi-society. This has been acknowledged by government, and as part of this current process to shift from the current equality body model to a national human rights institution that also takes on board its equality obligations under EU law, we're moving from a setup where we were looking at equality issues with a particular focus away from other, perhaps, rights that were enshrined in conventions and covenants that Malta is party to in our public discourse, to ensure that the public discourse actually encapsulates all the set of rights in the promotion. In fact, if one looks at the initial consultation document that Malta launched, it was very clear from that consultation process that this shift is already happening. That consultation process was launched in February of this year. The white paper is forthcoming. It will be launched in due course. And once more, that white paper will be giving greater direction in this regard. Of course, the mandate of that commission is still to be fully formed. So one is to, of course, look into the process closely and ensure that all checks and balances are included in that one, and that the promotion is done afterwards.
Thank you. And finally, there was a question by Mr. Sittelson concerning, if I understood well, whether we could provide case law regarding libel and defamation, and how do courts make a reference to public opinion on the appreciation of what is libel and what is defamation. After consulting the delegation, I can also promise that we would look into this and provide a particular example of a case law within 48 hours. Thank you.
Thank you very much, Ambassador Grech and your colleagues. Any follow-up questions from colleagues to the answers that we've just heard from the delegation? Mr. Flinterman, you have the floor.
Thank you, Mr. Chairman. I would like to thank the delegation once again for the responses given, sometimes in a very succinct manner, just as on the question raised by Madame Majudina on the minimum age of marriage. I was somewhat surprised to read both in the report and to hear it confirmed today that there is no intention to raise the minimum age of marriage from 16 to 18, as was also suggested by the Committee on the Rights of the Child to Malta some time ago. Because we have been informed in the context of the report that the average age of for women to enter marriage is in Malta 28.6 years, and for men it's 30.5 years. So in general, both women and men are very much thinking about the step to enter marriage. That's one. And secondly, given the importance of the protections of the rights of children, given the importance of the protection of children, I would find it important I would like to invite the delegation to bear this in mind and to rethink this particular issue in the coming period. And on the issue of the blind people having to appear before a group of people composed of representatives of political parties and the electoral commissions, I was not aware of the reservation by Malta to the relevant article in the Convention on the Rights of Disabled Persons, Article 29. To be honest, I was not aware of it. But it raises the interesting question of the relation between that particular convention and our covenant. Malta has not made a reservation to Article 25 of the covenant, which I think emphasizes very much that elections should be held by secret ballot. And my question to the delegation was whether the practice that blind people have to appear before a committee and in public have to indicate their political preference is compatible with Article 25, especially the secrecy of the ballot, and secondly, also with that important provision which is so much under threat in the present world of today, the right to privacy, the right not to have to indicate what your political preferences are. And for that reason, I would like to refer the delegation to, according to my information, to a very interesting proposal of representatives of the visually impaired in Malta who have asked the government of Malta to allow blind voters to have a person they trust to assist them while casting their vote. And I would think that's a solution that is followed in so many other countries around the world. What impediments are there to heed to these suggestions by representatives of those who are most affected by the present practice? Those were my two follow-up questions, Mr. Chair. Thank you.
Thank you very much, Mr. Flinteman. Mr. Bouzid, you have the floor.
شكرا سيد الرئيس.
Thank you, Mr. Chairman. I would like to thank the delegation for the answers we've heard from them to the questions that I put. But as regards the decriminalisation of vilification and defamation, the answer was a very brief one. And this response said that nothing will be changed for the moment. So my question is, what is the justification for this rigid attitude with regards to this state of play? Because I feel that this situation is not in tune with law number 19. I'd be grateful if I could get more clarification on that. Thank you very much.
Thank you, Mr. Bouzid. That's Article 19 of the covenant that Mr. Bouzid was referring to. Any other questions? If not, I also have a follow-up one on exactly the same point. In addition to the utility for the Committee of understanding the thinking of the State Party rather than the position of the State Party, it would be helpful to know, have there actually been any cases of prosecution for defamation or blasphemy or whatever it's actually called in Maltese law since the last report? Thank you. And with that, I return the floor to the delegation for its final round of responses. Over to you, Ambassador Grech. The floor's with you, Ambassador Gregg.
Thank you very much, Mr. Chairman. With respect to the question on the decriminalisation raised by Mr. Bouzid, we have, although the implication is that, as you said, it seems to be a rigid position, it is not rigid because the issue is continuously being discussed in Malta, because the overall intention of Capital is to further improve our performance in the context of the ICCPR in general. Therefore, this does not preclude that, as we speak, discussions are going on within Capital, within the competent authorities, for this to be further ameliorated. But our present position is that the position we've stated also in the context of our deliberations during these 2 days still stands. But I'm sure, and note has been taken, that your references to this in particular will be also considered as a further push in order that these internal considerations will bear fruit in the long run. Concerning the issue of people with a disability in the context of the voting hall, I pass on the word to our experts to add some additional information.
Thank you. Regarding the issue about the reservation in the UNCRPD, and this reservation is not made in Article 25 of the ICCPR, I can tell that we are aware of this issue. One has to know that the UNCRPD was ratified by Malta last November 2012. Thus, this came after the ratification of the ICCPR. We will, though, pass forward all the points raised to the relevant ministry for consideration. In regards to the secrecy, the right of secrecy to vote as declared in Article 25, as I stated earlier, the ballot papers, the voting sheets, I mean, are also available in Braille and MP3 formats and are made available upon request. I can add to this that very few people request such assistance, such formats. In fact, during the last general election in Malta, only 6 persons requested for the Braille or MP3 format ballot sheets. Finally, in regards to the issue of person of trust as suggested by visual impaired NGOs, the focal point office for the rights of persons with disability met already with NGOs, and this issue was raised in such meetings. As I told you, the Electoral Commission and the focal point office and even the Secretariat for Persons with Disability had already initiated meetings in this regards. Thus, this issue was forwarded to the Electoral Commission. Thank you.
Thank you very much. And that brings us to the end of what we have to offer today, Mr. Chairman.
Thank you very much, Ambassador Agius, in which case I then turn to the head of the delegation for his concluding remarks. You have the floor, sir.
Thank you, Mr. Chair, members of the committee, distinguished delegates, ladies and gentlemen. We, the Malta delegation, believe that this dialogue has been very thought-provoking and indeed very useful. And I'll go back to where we started, in fact. The advancement of human rights is an inherent aspect of Maltese politics, legislation, and way of life. Malta continues to advocate for the protection and promotion of the fundamental values enshrined in the Universal Declaration of Human Rights and its subsequent covenants. These values are deeply rooted in the building blocks of Maltese society, starting from the Constitution all the way to the various bodies established to protect and promote human rights in all their facets. Malta will therefore be looking into the issues raised and seriously evaluating its performance today, but also over the years to come. We also look forward to the concluding observations from this committee and look forward to work with you in other ways, however they are, as they are possible. Thank you very much.
Thank you very much, Ms. Dragius, Head of Delegation. Thanks to the whole delegation. It was very good having a delegation that was clearly interministerial, interdepartmental, and able to provide a lot of concrete information in response to colleagues' questions and within the limits of the possibilities and instructions. We very much appreciated the delegations engaging in what really was a constructive dialogue. We note some very, very positive developments. Of course, the ratification of the second optional protocol to our covenant. It's quite clear that the progress that the state parties made in terms of eliminating discrimination on grounds of sexual orientation and gender identity is exemplary, and not just in terms of the law, but in terms of public awareness raising as well. It's clearly been a very impressive development. There's also been good developments in the area of promotion of gender equality, though clearly there's room for further improvement there, not least in the area of the legislature. The banning of corporal punishment of children under all circumstances is also an extremely positive development. So there really has been a lot to report since the last report, the first report of the state party. I also appreciate that despite our disappointment that with regard to the non-removal of reservations, there is now an undertaking to review those reservations, especially those that are palpably out of date by virtue of either changes in legislation or incurring of international obligations in other treaties, so as to make some of the reservations obsolete. But it would be good also if consideration could be given to the non-obsolete ones as well. The issue of the issue of defamation of religion, I didn't hear an answer, and I presume it was because the information wasn't available and might come perhaps in the next 48 hours as to whether there have been any prosecutions for defamation of religion. It would be useful for the committee to know that before formulating its concluding observations. But clearly I appreciated the attempt of the delegation to try and find a way of indicating that the state parties' ears were open on the issue. As I said during the discussion, Article 19 and Article 18 and Article 26 altogether do make the maintenance, as reflected in General Comment 34 of the committee, the maintenance of this privileged position for one religion to be difficult to reconcile with the state parties' obligations under the covenant. On the issue of abortion, a number of questions were raised by colleagues, and each time the response included a reference to family planning. This committee is not asking about family planning. It's asking about respect for the provisions of the covenant, including the one that the state party is relying on wholly, which is the right to life. And just in terms of the right to life, it's certainly not clear to the committee how any state party, and as Ms. Zybert says, this is an issue that we take up with all states parties with particularly restrictive laws. It is simply not clear how the only possible implication of the law is that the state party is preferring the life of the unborn child over the life of the born mother. And that just seems very difficult to understand. The introduction by the head of the delegation said that Malta is also committed to the promotion of sexual and reproductive health and to the protection of the right of women to have control over and decide freely and responsibly on matters related to their sexuality and the timing, number and spacing of children, free of coercion, discrimination and violence. Well, that's highly commendable. Exactly how forcing a woman to carry to term a pregnancy that is the result of rape is consistent with that policy is again very difficult to understand for those who aren't part of the belief system that the state party is espousing. I won't go further on the issue of the implications of incest and potential grave harm to health of the mother, but that may not be life-threatening as such, but could affect the life project of generations. So the delegation should not be too surprised that this will be an issue that will figure in the concluding observations of the committee. The fact remains, I'll say something on the positive side, as well, I started by doing that. I also started the discussion yesterday by doing that. It is clear that Malta is a state that is open, free, and respects human rights in a very serious and general way. I've visited the country myself and seen it for myself, not as an investigator, but as a visitor, and it's obviously the case. But at the same time, the issues remain, as there are issues with all states parties to the covenant. I've yet to see a state party come before this committee, and we don't have any concerns to express to that state party. Malta, of course, is no different. So it's been a useful discussion from the committee's point of view to learn what the developments have been from in Malta, and to have the opportunity to explain some of the interpretations that the committee gives to the covenant to the state party. So we now just wish you a safe home after a few days in Geneva, for those who are visiting it, though I can see why people would be wishing to get as quickly back to Malta as possible. Wish I were coming too, and wish you safe home. Thank the delegation very much for the exchange, and look forward then to follow up after we've adopted the concluding observations. Thank you very much, delegation. The meeting is suspended. Just to say that as soon as the room is cleared, we're going to go into closed session and continue with communications. So in 5 minutes, the meeting suspended.